the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel for both of the cases we'll be hearing this morning. To my right and your left is Justice Amy Blake. To my left and your right is Justice John Englander. As I mentioned, we are hearing only two cases this morning. It was an abbreviated list originally consisting of three cases. One of those cases has announced a settlement, and we are left with two matters. We are familiar with the procedural history, the factual background in each case. You needn't remind us of that. We will have questions for you. Each side has 15 minutes to argue, and without further, and there is no rebuttal. Without further introductories, let me call the first case, case number 2022 P850, Sugarman and Sugarman PC, and another versus Daniel B. Shapiro and another.
May I proceed? Good morning, Your Honors. Attorney Richard Reiling on behalf of the defendant appellant Daniel Shapiro. As Your Honors are aware, Attorney Shapiro was the founder of a federal workers' compensation practice, and this case involves a failed collaboration between two law firms, his law firm, Shapiro & Associates, and the personal injury firm of Sugarman & Sugarman. In this case, Sugarman & Sugarman filed suit originally for breach of contract, claimed that Attorney Shapiro was an employee, and sued for the reasonable value of the services that they rendered or claimed to have rendered in connection with the OWCP cases before the Office of Workers' Compensation Programs, which is administered by the Department of Justice. The jury did not find in Sugarman's favor on the breach of contract case or the breach of duty of loyalty case, but with the evaluation of the court's subject matter jurisdiction to even hear that claim. The claim, as a matter of federal law, is barred. All compensation received...
Let's assume you're right. I don't think that's a subject matter jurisdiction argument, though, is it, counsel? I mean, this is a contract and quantum merit claim in state court between two Massachusetts residents. The Superior Court has jurisdiction over it.
Your Honor, this particular claim, since it involves compensation for federal workers' compensation programs, is specifically...
No, it's a claim for breach of contract. It may be a defense, I suppose, that the court can't order the particular relief, but it's not a subject matter jurisdiction issue. It's not an issue of the court's power to decide the claim that's in front of it.
Your Honor, the statute itself, which has been in place since 1966, specifically says that no claim is valid unless it's submitted to the Department of Labor. And that's a matter...
That's the claim for the workman's compensation attorney's fees.
That's correct, but no claim for any fees rendered in a federal workers' compensation case is valid.
But this is not, strictly speaking, a claim for the fees themselves. It's a dispute as among two partners for the allocation of those fees after they are paid.
Yes, Your Honor. That is what the parties stipulated to.
There are lots and lots of disputes that concern entitlement to shares of funds that have an underlying source from a regulated industry. But that doesn't derogate from the ability to evaluate the competing claims for those fees after they are paid.
After they are paid. And that was the discussion that the parties had during the course of the argument on summary judgment in December year 2019. The defendant had brought a motion to dismiss for lack of subject matter jurisdiction, and counsel for Sugarman at that point stipulated that they were only seeking fees that had actually been received by Attorney Shapiro. Now, we hear something totally different at trial. There was no proof that the fees were approved by the Department of Labor, approved by the clients, or actually received by Attorney Shapiro. In the event that they had demonstrated that,
Well, that is, it seems to me, an entirely separate concern that you've raised about whether it was appropriate to award relief based on fees that hadn't been paid. But it seems to me that the underlying question between these two parties is the value conferred. This is on a claim of quantum merit, and you know, we can get separately to the question whether the relief ought to be limited to what he actually received, because he can't have received a benefit from the firm that never materialized into any benefit to him, is your argument. But that, again, does not go to the question of subject matter jurisdiction. Now, you've got 10 minutes left. You've raised a number of different arguments, and I'm not sure this is the one where we should be spending most of our time.
well, Your Honor, let me move on to the issue of quantum merit. In order to prove quantum merit, it's incumbent on Sugarman to demonstrate that they concurred a benefit on Attorney Shapiro. They didn't do that.
So let's break this down. I think these issues need to be broken down. So your first statement is it's incumbent to show that they've conferred a benefit. You made that argument as a matter of the jury instructions. Do you think that the jury was instructed that they had to find that a benefit had been conferred?
They were not, Your Honor. That was specifically excluded from the instruction over our objection. The jury was not instructed that a benefit needed to be incurred.
What about the language at the beginning of the charge where he actually mentions a benefit? Right at the beginning of the charge on quantum merit, he says, quantum merit is a claim where you've benefited the defendant.
But when the judge, Your Honor, was explaining the elements of this particular claim to the jury over our objection, he did not mention that it was necessary to confer a benefit. And to hearken back to the discussion with Chief Justice Green, in order to incur a benefit, it needs to be approved by the Department of Labor. It needs to be approved by the
why do you
client
say that?
and received, and actually received.
So why? Why do you say that? I mean, the plaintiffs proved that they did a lot of. I'm sorry. The plaintiffs proved that they did a lot of work for Shapiro.
Correct.
On a lot of cases, right? The cases were identified. They proved that they did a lot of work for them. Why isn't that proof enough that a benefit has been conferred?
Well, the specific value of the benefit, they were claiming that they were entitled to fees at the rate of $795.
You could imagine a scenario where someone subcontracts work out and does so on an hourly rate, without regard to whether they ultimately collect for the project that they are receiving those services for.
Your Honor, that was not the contract between the parties.
I understand, that's a different argument. As I understand it, your claim on quantum merit is that the judge erred fundamentally in allowing that question to go to the jury.
Yes, Your Honor, without an instruction that there needs to be a measurable benefit incurred by Attorney Shapiro.
So, counsel, are you familiar with the case called Liss against Stedeni?
I am, Your Honor.
Okay, so Liss actually deals with a somewhat comparable situation of work that's done in connection with somebody who's ultimately going to seek a contingency fee, right?
That's correct, Your Honor.
And it specifically says that whether or not a fee was recovered, a benefit was conferred.
To the attorney.
A benefit was conferred by the work done by the lawyers for that lawyer, right?
And that was in a case where the contingent fee was actually received. In this case, there's no proof of that.
No, it addresses the question separately from whether the contingency fee was received. I have to get the page, but I'm reading it right now. It's highlighted in blue here. I didn't recall reading any of this in the briefs. I think it's a complicated and interesting problem, to be honest. What Liss against Stedeni ultimately says is because the contingency fee was not received, as I recall, that it was not within the reasonable expectation of the parties involved that the people who performed the work for the lawyer who ultimately got the contingency would be compensated for that. Do I have the case right?
I think you do, Your Honor. In that case, there was not a quantum merit award based on the fact that there was no ultimate contingent fee given. And in this case...
But how did you preserve that argument before the trial judge? Because that, it sounds to me like I should have won a motion for directed verdict.
And we raised that, Your Honor.
I read your motion for directed verdict.
Well, we raised in the motion for directed verdict at the close of Sugarman's evidence, we indicated that number one, that there was no proof that it was approved by the Department of Labor or the clients, or actually received by Attorney Shapiro, and that there was no measurable benefit conferred. And we also argued that the parties had stipulated, and of course this goes to another point in our brief, that this was a fully integrated contract.
You mentioned the fact that there was no proof, but that last little phrase that you just said, and we argued that there was no measurable benefit conferred, I didn't read that in your motion for directed verdict. Now, maybe I misunderstood it, but I didn't read that.
Well, again, Your Honor, when we made the motion for directed verdict, both at that point and at the close of the evidence, we argued that the elements of the quantum merit claim had not been met. We did focus on the fact that there was no proof that Attorney Shapiro actually received the funds. And in this case, the party's reasonable expectation was not $795 an hour. It was a third. The contingent fee agreement specifically indicates that it's a third of what's recovered. That's what the parties expected. In accordance with the terms of the contract.
That doesn't... I mean, one of the problems, and it's another argument that you make, is going to what the parties expected. What we're really asking is, what did Sugarman firm expect to recover from whatever it is that the Shapiro piece recovered? Right? Isn't that the question?
It is, Your Honor.
It's not a third. You weren't going to take everything that you recovered and hand it over. And that really gets to what is the contract.
It does, Your Honor, and the contract itself, which the parties stipulated, which is rare, is a fully integrated contract, provides specific payment terms in year 1 and 2. In year 1, it was pay for services.
You keep describing that as a stipulation, but plainly the judge did not consider that to be a binding stipulation in the context of the trial, because he allowed the question of quantum merit to go to the jury.
He did, Your Honor, despite the fact that during opening statements...
Well, I understand, but why don't we talk about the question whether it is or is not a proper claim, despite the existence of a written contract, without placing such reliance on what may or may not have been a legally binding stipulation.
Okay. Well,
because it seems to me that question of whether this is or isn't encompassed within the written contract is an interesting and difficult question which you're trying to evade by characterizing something as a stipulation that all others involved in the trial did not view as such.
And Your Honor, I don't, we're not trying to evade that issue.
Why don't we talk about it then?
Okay. The contract itself, I mean, first of all, unlike most contracts that involve issues of fully integrated nature, both parties, both sophisticated law firms, have agreed that it is fully integrated and we can't look outside the terms of the contract.
You can't help yourself, can you?
I suppose not, because that's the facts. And
it doesn't help us. I mean, and there was law that was cited. I mean, this is not new to you.
And you're running out of time.
This is law that was cited to you by the trial judge and has been cited in the briefs about the nature of the contract. Let me ask this question, because this is what's really going through my mind, at least. What do you think should happen under the contract where your client leaves in the middle of year 2, takes all the work with him, and takes all the money that comes from that work, what should happen? What do you think the contract says about what he then has to pay, if anything?
The contract does not say that he has to pay anything.
So let me stop. So your view is the contract, because he can leave in the middle of year 2 and pay no more dollars. That's your position.
And the judge, in your view, should have instructed as such.
Unfortunately, it's a little bit more complicated than that, because in year 1 of the contract, it's pay for services. In year 2 of the contract, Sugarman was entitled to a percentage of the net. That's what the contract provides. That's
assuming assuming that they actually carry through to the end of the year. Isn't that an implicit assumption in the contract?
Not
based on the payment terms. The payment terms aren't yearly.
So your view, again, just to be clear about it, your position is that at any time before the conclusion of year 2, Shapiro could leave the contract, take everything with him, and pay nothing for anything that happened after the end of year 1.
And that's the facts.
For the terms of the contract.
Under the terms of the contract, it does not provide for any payments outside of the terms of the contract.
It's not a question of what it doesn't provide. You're suggesting that because it doesn't provide, that is the result, and that's what the correct interpretation of the contract terms would be.
In a fully integrated contract, that's correct.
Thank you.
And I'm out of time. Thank you.
Good morning. My name is Alan David. I'm here with my colleague, Ivana Epperson-Temple, and we represent Sugarman. And I'd like to focus the argument on the quantum merit, because that is...
Why don't we pick up right where we left off, and I'd like to hear your views on how this question of what happens in circumstances as unfolded here, what that does to payment under the terms of the contract, or whether, because the contract was silent, that meant the contract needed to be set aside for a theory of quantum merit to be put to the jury.
The contract didn't need to be set aside, and there is a provision in the contract saying that it is a complete agreement. I think the language is with respect to the subject matter contained herein. So as long as there is something in the contract dealing with this, the contract will control, and no one ever suggested anything else. The contract here doesn't deal with what happens if there is a termination between years 1 and 2. Now, you may think it should have. It's entirely foreseeable that could happen, but it doesn't. And the trial judge made an observation and a request of Mr. Shapiro.
Well, someone could, if I could,
Sure.
Someone could argue that the contract does deal with it in the sense that it just doesn't provide that Sugarman's going to be paid if what happens here happens. In the middle of year 2, Shapiro leaves.
But what in the contract, following that line of argument, what in the contract allows Mr. Shapiro to take everything? There's no contract
But
based...
that seems to me is an entirely different question. I mean, that would be a question of whether there was a breach with what he did, which I guess you guys tried and you lost, right?
There were cross claims for breach of contract, and the jury found that neither party breached the contract.
Right. So, but, your answer to me, it seems to me, would be covered by your breach of contract claim, not by your quantum merit claim. I mean, his argument is, look, if you look at a quote-unquote fully integrated contract, doesn't provide that I have to make any payments if I walk away in the middle of year 2, other than, the numbers that are there. And it turns out that there wasn't enough money for us to have to pay Sugarman anything, so that's the end of the story.
In fact, there was plenty of money, but the point is, this contract doesn't deal with that. This is not part of the subject matter contained herein, which is the language of the contract. And the law on this
A broad view of the subject matter of the contract is the relationship between Shapiro and Sugarman, and the mutual arrangements for services and an allocation of the payments. All of that is addressed. Now, the contract may have been ambiguous. It may have been capable of different interpretations or even incomplete as to one aspect of that relationship. But that doesn't mean that that aspect is not encompassed within the subject matter of the contract.
If it were a question of ambiguity, I would agree with Your Honor. This is not a question of ambiguity. This is a question of silence. There is nothing dealing with what happens if there is a termination before the end of year 2.
So I apologize if you've already done this in your brief, but it would be helpful to me to have the clearest case addressing similar circumstances where there is a complete contract between two counterparties and something within the scope of the relationship described by that contract between the parties that, on which the contract is silent, that is then treated as an appropriate subject for a claim of quantum merit. What is the best case on that?
I think this court decided in an unpublished decision in 2010, hurling...
Well, I'd really like to get a published
Pardon me?
case. I'd really like to get a published case.
Off the top of my head in Massachusetts, I'm not aware of a particular case like this, other than the unpublished case, where the contract
What do you have from any
silent.
other jurisdiction?
Pardon me?
What do you have, if anything, from any other jurisdiction?
We have cited a number of cases in our brief from other jurisdictions where what happened was generally covered by the contract in the sense that it happened in the context of the business relationship. That's a very general view of what is covered by the contract, but I think it's appropriate for this case that this happened in the context of that business relationship. Specifically, how is this particular thing to be dealt with is not in the contract at all.
Can we,
And that is, I think, under the, what
can we
case law exists
switch,
in
can we
Massachusetts
switch
and-
gears? Sure. Yeah. Shouldn't the jury have been instructed that they had to, that your client had to confer a benefit? Isn't that the way that the formulation of quantum merit or quasi-contract is usually found in the restatement and otherwise?
Well, yes, they would have to be instructed in appropriate language on quantum merit, and they were.
They were, because you don't think there's a difference between saying show they perform services, which, by the way, everyone agrees, and show they conferred a benefit?
I think that performing services for someone implies a benefit. That language is right out of the cases. That language is in the Superior Court model jury instructions. That was the language that the trial judge used.
Performing services implies a benefit. I quickly read the restatement comments yesterday, but, you know, going back a long time because I'm old,
Yeah.
my memory is that there's a difference between performing services and benefits, which the law has always seen, which is, you know, if you go and you do something for somebody that they really didn't need, they don't have to pay you for it.
That's true, but I don't think it's particularly relevant to this situation where two groups of lawyers were working together to produce a result.
And I understand that point. I understand the point that there probably was a benefit conferred, and I'm going to ask you about lists in a minute, but shouldn't the jury have been instructed that?
Well, they were instructed on the elements of quantum merit, and the cases use the word service. The objection to the charge was not, I want you to use different language, Judge, which may or may not be a good objection. It was, you shouldn't be giving these instructions at all.
No, they also objected on benefit. He made a very specific objection that it should say benefit, and he did it at the right time. It's preserved. If I could, there's a different question, all right, in addition to the jury instruction question, which is, what's your burden of proof? And are you familiar with the list case that I mentioned?
I am.
So your opponent says, you didn't prove your case because you didn't show that the monies that your client wants to recover in quantum merit were actually recovered through a contingency fee in the on the workers' comp side. What do you say to that? And for a moment, let's leave aside the question of whether he's preserved that through his directed verdict motion, okay?
I have two responses to that. One of them ties into the List case. There are two ways to look at this. Mr. Shapiro walked out the door with 400 additional cases and 8,000 hours of lawyer time and paralegal time. Depending how you do the math, that has a value in the low to mid 6-7 figures. Now, what he does with that is totally up to him. He can collect it. He can try to spite Sugarman and say, I'm going to sit on this. Tough. But that's totally up to him what he does with it. The fact is he left Sugarman with a very valuable asset. The other way to look at it, more concretely.
Well, so that divorces the concept of what Sugarman provided from the concept of whether any of that was recovered by Shapiro.
Right. It sounds to me as though what we're playing with here is a distinction between unjust enrichment and quantum merit as equitable grounds for recovery. Do the two merge, or is the distinction that sharp?
That's a very subtle distinction in this case. But if I could go
well, but the fundamental question is whether, in order to recover in quantum merit, our inquiry is confined to the services provided by the requesting party, or whether it's measured by the value realized by the party to whom those services were provided.
I think either way the court analyzes it, in this case, you come out to the same place.
Without proof of value realized?
Pardon me?
Without proof of value realized?
Well, here's the proof of value realized. And I don't ordinarily do this, but it's a very short exchange of testimony during the trial of Mr. Shapiro. And it's on page 22 of the brief. And you were billing at $795 per hour. I was for me, yes. And for Sugarman attorneys at the same rate? Yes. And was that a fair rate for the work that was being performed? I believe so. And the clients paid you that? Yes. And by the way, they paid. They approved it, and the $795 has also been approved by the Department of Labor hundreds of times, too. Okay, since December 15th, 2017, the date Mr. Shapiro left, you have been billing OWCP clients and collecting for work that had been performed by the clients. Is that correct? Answer, I have been billing clients since December 15th.
Right.
And yes,
I'm
I
on
have
the
been
same page of your brief as
Pardon
you
me?
are. I see what you're talking
Okay,
about.
as I said, I don't usually do that, but I think this testimony is very
No,
graphic,
that's helpful.
very dramatic.
No, that's helpful. It's helpful.
He billed for it.
Well, we don't know exactly what he billed for, and we don't know exactly what he collected. That evidence did not come in. I'm sure some of these cases he did. He didn't win every one of them. And some of them, the money that was billed would have been larger than 1/3 of the fee. And we don't know that either.
We don't. What we do know is that he was billing and collecting at $795 an hour for his time and Sugarman's time, and not writing off any of Sugarman's time. And the jury awarded a fraction of the work he took with him. And we can figure out, we know what the basis was. The jury didn't say, but
Well,
it
yeah,
comes out
there's
to
a
the
pretty
penny.
close correspondence if you do the math.
You can do the math, yeah. I mean, it comes out to the penny. But the fact is, this has always been, from Mr. Shapiro's point of view, an exercise in burden of proof. He has never denied that he got the money. If he had not received the money, you would think he would have seen that. And yes, the plaintiff has the burden of proof in these things. Without the evidence, which is what we had, the only evidence we had on this. Mr. Shapiro was ordered to produce what he had received.
Yeah,
He didn't do it.
I understand. I read that in your brief. I think just judging by what you just said, you understand the difficulty with that argument. I mean, it's your burden of proof, and you needed to find some way to carry your burden with them not producing what they were ordered to produce.
And I believe that we have done so with that exchange of testimony of Mr. Shapiro acknowledging that he has been billing and collecting at $795 an hour.
Understand the argument.
If there are no
Minute
further
left.
questions.
Anything else you want to address?
No, I think we have covered it. Thank you.
Thank you both. The case is submitted. The second case on our list is case number 2022 P803, John McLaughlin versus the Town of Duxbury Zoning Board of Appeals and others.
I might have another question there.
Good morning. May it please the court, my name is Amy Quessel. I represent the Duxbury Zoning Board of Appeals. As Chief Justice explained, you guys know the procedural history. Just briefly, this is a case regarding a dock in the...
I think we know that.
in the-
Could I ask you to
sure.
look at volume 4? I have questions about the pictures. And I'm looking at, I believe it's page 126. I think it's Exhibit 16H.
Yes, I'm there.
All right. So I assume that the area in question is in the, sort of the middle of that photo where there's some jagged edges. Is that right?
Correct.
Is there anything in the record that shows us where the pier would end? Because from this, I couldn't find anything that showed me that.
So the plan would show that that the pier ends approximately 1/3 of the way in, is what I would...
So if you're looking at that picture, and this is a terrible description I'm going to give you, but on the left, if you're coming from the house, there's some jagged edge, and then it juts to the left before it goes back straight out. Where it juts to the left, is that where the pier would end?
In that general vicinity, correct.
So it would have to go, as I understand it, from your expert and from the board, all the way to the end of that land.
Yes, so that
Is
is...
that on the left or the right? Because the right is much shorter than the left.
It's on the right. So the house, as you can see in the picture, the house, to be comparable to every other dock on the Bluefish River in Duxbury Bay, they would just go straight out. However, they can't do that because it's over 200 feet.
I was having a little bit more difficulty following the description that you and Judge Blake just engaged in. I'm looking at Exhibit 16H. I see a rather long finger that approaches the finger of water that approaches the what appears to be the house.
Correct.
And on the right, I see a shorter peninsula that goes out. On the left, I see a longer one. Where was the proposed pier to have ended?
On the shorter peninsula, so to the right of the waterway, going directly straight out from the house and ending, I would say, approximately 2/3 coming in of that inlet. I mean, 1/3.
So one thing that might be helpful is Record Appendix 1, page 686, which shows the location of the float.
What page?
It's RA1 686. That's the only proposed plan that I could find in the record. So if you put that, next to
I see.
next to
Yep.
what Judge Blake has identified,
Yep.
you can get a little bit of a sense of where it ends.
Yeah.
So I appreciate the help from Judge Englander, but I want to ask you again about the photos, because having a clearer understanding now, if you look to the photos that show the other dock, so I think that starts in that same volume at, let's see, 16M, and it appears that each of those docks is completely past what we're calling the fingers, if you will.
Yeah, or the salt marsh.
Right, so this is the only proposed dock on this area of water and land that would not extend all the way out. Every other one extends all the way out.
Correct, that was the testimony. It doglegs, so it takes a 90-degree turn, I'm sorry, to go into that inlet because it cannot go straight.
So I know that the bylaw says 200 feet, right?
Correct.
If they had a proposal that extended it so it went all the way out the way the others do, so that you don't have the question of tidal flat versus tidal creek, the board would have presumably rejected that because it exceeds the 200.
Correct, it would need a variance.
So there's no way that they can build a zoning bylaw compliant dock from this house?
Correct, in the opinion of the board, yes.
Ever?
That is correct. That is correct, unless the bylaw changes.
Or they get a variance.
Exactly, exactly.
I know I interrupted where you were
That's
going with
okay.
your argument because I wanted to understand what we were looking at. I'm happy to let you get back to it, but can I ask you, and I know we're jumping around, I have no idea where we're going to come out, but just assume that we don't overturn Judge Smith's decision on the erroneous findings, or the argument that they are. What, if we were to order it the judge to order it remanded to the board, what would that essentially do? As I read Judge Smith's opinion, he basically says it's useless to do so. They've already made up their mind. We're just going to order the special permit to issue. And I know what the case law says about that. I'm trying to understand as a practical matter, you make the argument that there could be conditions associated with the issuance. So what kinds of conditions are we talking about?
There can be conditions with regard to materials that are going to be used. There can be conditions with regard to, in the winter, when the float comes up, where the float is stored. This is in, again, I do want to emphasize, it's in the Wetland Protection Overlay District. So it's very likely that any special permit granted would have conditions.
Would that include doing something with respect to the wetlands and the wildlife and the flora and fauna?
Correct, which is, for example, the salt marsh. The pier goes over the salt marsh. Obviously, we don't want the float to just come up and all winter long sit on the salt marsh. We would like it to be stored in the upland, things like that. You know, again, I
Never got there because the board
Never.
denied the permit and the judge ordered it to issue.
correct.
Let me ask a somewhat different question, though, on this same topic, because I couldn't tell from your argument on this point in the brief whether you also adhere to the view that it would be open to the board to deny a special permit entirely if we were to affirm Judge Smith's interpretation of the applicability of the bylaw to this particular project site as it relates to open water.
So, Your Honor, there is case law that says that even if a project meets all of the elements, the board does have some
So your answer
discretion.
is that the board could deny a permit entirely despite the fact that it would otherwise meet the underlying criteria for eligibility for special permit?
Your Honor, in this circumstance, due to the language in the decision, no, the board stated that it meets every single element other than this one. And
So if this one is satisfied, the board, your view is that the board would be solely concerned with conditions and not with whether to approve or deny the permit?
unless there was new information presented. I can't speak for the board, But that would, I did sit through all the zoning board hearings with the board. I worked with them on the decision. I've been through this case.
What would the rules be with respect to adding new evidence at this point? I mean, you know, the questions are, to me, very interesting coming from my panelists. Assume that you get what you want only with respect to the second issue you've raised, that it goes back. I hear you saying if it goes back, because if we affirm the decision of the judge, except as to his decision to compel the special permit to be granted, there wouldn't be any discretion left in the board to deny, quote, unless there was new evidence presented. What would the rules be with respect to that? Haven't we already had a trial on this?
We have, Your Honor. However, I think that, again, first of all, I think that the judge erred in making that factual
We
finding.
understand. This is a hypothetical assumption.
Right. And the board does have great discretion with regard to special permits and making decisions on special permits. In this instance, the board's decision clearly states that the pier meets every other
Correct.
element except for this one. If this is remanded back to the board with the finding that it's a tidal flat, the board will have to discuss that. It is a public hearing, Your Honor.
It was before your time, but I'm certain that you are familiar with the McGibbon case.
I am, and that, this is different. This is different because...
Well, because it's only been up here once.
While it is the same...
Just saying. And that's the
And you
reason
have-
I'm asking the question about what your view is of the
Yes.
latitude the board would have in the event of a remand.
Yes. So-
that takes away the only stated ground for denial.
So McGibbon is different. It's the same special permit granting authority. It is Duxbury. It was years ago. However, in McGibbon, it went back 3 times. And, you know, and again,
I'm not sure we would necessarily go to a third time.
No.
It's been 13 years since this person applied for the permit. You know, at some point, things need to be decided. And I understand the difficulty with you standing up here, but we're asking the question, you know, if it goes back for the second reason that you've identified, because there would be conditions to be applied, but there's no discretion left to deny, then, you know, the notion that they're going to take new evidence and come up with another reason is very troubling to me.
So, Your Honor, first of all, it has been 13 years. They've only applied to the Zoning Board of Appeals once. This is it. The prior litigation had to do with the Conservation Commission. Again, in our summary judgment in land court and in my brief, I specifically point out that the Conservation Commission and the Zoning Board are different.
I understand the history.
Regulatory authorities. Now, I guess you would have to consider every time it goes back to a zoning board, are you concerned that they're going to find new reasons, et cetera? It goes back, it's a public hearing.
The concern that the opportunity for the public to participate in an open hearing about potential conditions that would be appropriate to bound the approval if it is compelled to be granted because of an erroneous legal determination by the board in the first instance. I mean, I used to do some of this stuff and harbored relatively little concern that the board was going to engage in mischief on the remand, and happily that seemed very seldom to occur. Just trying to...
And I don't expect anything nefarious to happen with this zoning board. They're experienced, again, their decision states that every other element was met. And again, I do just want to address Justice Englander's concern, which is that if it does get remanded, it is a public hearing. So it has to be advertised, it has to be noticed.
Yeah.
And with a public hearing, there's a due process issue.
That actually, to me, brings up an interesting issue about the amicus and the motion to intervene, because when the judge ruled that the neighbors or the abutters couldn't intervene, he basically said, if the board is wrong, you'll have your day in court. But in the manner in which he then issued his judgment to order the special permit to issue, that truncated anything. And my understanding is the interveners did not appeal the motion to deny the intervention, but if we were to uphold Judge Smith but send it back, as we've discussed, how, if at all, does that impact the interveners?
The interveners would be abutters, they would be noticed, it would be a public hearing, they can offer testimony, I guess, at the public hearing, but yes, it would be a special permit that they could appeal. I also think that ordering it to be issued within 30 days would also allow them to appeal it under 48 Section 17. So I'm not really sure that it matters. I do have to argue the fact that under the Basque case, there is...
Whoa, let me just think about that for a moment. Are you suggesting that even if we affirm, there's still an appeal to be taken from the executive action of granting the permit?
So that, it's an interesting point, because I haven't necessarily found anything on point with it, but you cannot issue a special permit. They have to issue the special permit. It has to go to the town clerk.
I understand your point.
He
Okay.
ordered it to be issued. But again, with the Basque case, I have very little time.
Yeah, and we may go over it, because there are questions I have about the merits at least, but,
I want to.
yeah.
So I just wanted to say, with regard to the Basque case, I'm not necessarily certain that the land court has the jurisdiction to order a special permit to be issued.
Basque doesn't have anything to do with that. I mean, in fact, the special permit was ordered by the land court judge in Basque, and that was affirmed.
No, that was overturned by the...
What was overturned was the order that they stay licensing in a
Finding,
separate
yeah.
proceeding that was outside the land court's jurisdiction.
Correct, but there are also, there's other cases that say that the land court is of limited jurisdiction. They can annul, which is obviously what happened here.
The land court, I believe, has jurisdiction in appropriate instances to direct the issuance of a permit based on the conclusion of a 17 appeal.
And I would agree.
It's an unusual
Right.
result, but it's not extra jurisdictional in my understanding of things.
And I would
That's mine as
agree.
well. And having been the single justice on Basque, I have some experience with this.
I have experience from a slightly different perspective, but I used to do a little bit of this stuff.
Yes.
I have another question for you, if I may, Mr.
Please.
Panel Chief. You say in your brief at, I think, page 7 or 8, that because McLaughlin labeled the area as a tidal creek, that has some value here. And I'm going to ask Mr. McLaughlin's attorney. They respond, and then you respond in the reply brief. So what legal distinction does the title on a plan have for the ultimate issue in this case? If they had called it an elephant, would it have mattered? And I'm being that remote, because does it really matter what the person that drew the plans called it? Isn't that the board's job to figure out what it is?
Yes, correct. However, the point is that they labeled it a tidal creek and then changed course after meeting with their team and decided to call it, a tidal flat.
What if they had called it nothing? There was no title. It didn't say tidal creek or tidal flat. It said nothing.
Well, then it would be part of the salt marsh, as the salt marsh is on either side of it.
Because that's how the bylaw defines it.
The bylaw does not define salt marsh, it doesn't define tidal flat, doesn't define
creek.
tidal creek.
Neither do the wetlands regulations.
The wetland regulations define tidal flat and they define salt marsh. They do not define tidal creek.
Right.
So you say on page 22 that a tidal flat must be part of a coastal beach.
Correct.
What is the authority for that?
The Wetland Protection Act,
Okay.
1027, 310.
Not Duxbury?
No.
Okay.
No, that is in the Wetland Protection Act regulations. And again, a tidal flat has to be part of a coastal beach. There's no designation of a coastal beach. In fact,
If that's your position, I don't understand the testimony of your expert that I read yesterday, where she seemed to concede that there are areas of tidal flat very close to the area that she claims is a tidal creek right here. I mean, she concedes it.
But there would be a coastal beach associated with.
What's the coastal beach associated with any of that area?
It would be upland of the inlet, which they didn't designate and they claimed was not there.
But my point is, your expert conceded that very close to what she's claiming is a tidal creek where this float is going to be, there was tidal flat. But there was no beach near there.
Well-
And she conceded it's a tidal flat.
Well, again, the definition requires a coastal beach, and plaintiffs' experts conceded that there was no coastal beach, that they're somehow inferred together, yet that's not how the Wetlands Protection Act
Your
has them. They're
position is
separate.
without a coastal beach, you can't have a tidal flat. You can't have an area that's between mean low and mean high that becomes bare at some point. That can't be a tidal flat at all, ever. That's
Your
the
Honor,
position?
Your Honor, it would not meet the definition of tidal flat in the regulations. The regulations say coastal beach.
And three experts testified, and the way I read the testimony, two of them clearly said it could be tidal flat without a beach, and your client seemed to concede that this area is. But anyway,
Not to put too fine a point on it, but the term tidal flat doesn't appear in the bylaw, does it?
No, not in the zoning bylaw, no.
Right. So what we're concerned with here is how best to interpret the meaning of the edge of the marsh.
Correct.
And where it meets open water.
To the water's edge
Right, to the water's edge,
is the term, correct.
water's edge.
Is it true, as the amicus have suggested, that McLaughlin's property already is burdened by an existing pier, and therefore he cannot have a second pier?
There is a pier on the property that is in disrepair, so that, I'm not certain that that would preclude another pier.
Okay.
All right, we're well over time.
I have some more questions.
Okay,
I'm sorry, but
please.
as to the question of what's a tidal creek versus salt marsh, so your opponent says that the position that was taken by your client was that the entire area in which water flows in and flows out is a tidal creek,
Correct.
including over the tops of what we would all think of as a salt marsh, the area that's vegetated?
No. That's not the testimony that I recall.
So how do you delineate between, you just look at it by eyeball and say, well, that area's got vegetation, this area doesn't, so the area that doesn't is a tidal creek?
The water flows in and out. There's a mouth to the creek.
The water flows in and out of Bluefish River.
Correct. It's a river. There's river, the stream.
It's a tidal
creek.
estuary more than a river.
Exactly.
And the water it's going to be tidal, the water's going to be flowing in as the tide's coming in, and the water's going to be flowing out as the tide recedes. And that means that even the entirety of Bluefish River is not open water or a tidal flat?
No, it is.
The distinction that you're drawing is, you're losing me a little bit.
I'm sorry. The whole point of tidal creek is that the definition of salt marsh includes, it says that tidal creeks may be part of
Right, but
the
the
salt
problem
marsh.
is, what is a tidal creek versus what is a salt marsh? Because what is a salt marsh has the operative, that's the operative importance in the Duxbury bylaw, right? You have to get past the salt marsh.
Correct.
Okay, so, I'm not an expert, but I've lived near the water. The water comes in on the tide, and it comes right over the vegetated area of the salt marsh. It flows in, and it flows out. So how do we know which part of this is a tidal creek and which part is not on the testimony that says, well, it's where the water flows in and flows out? It flows in right over the vegetation as well.
There's a definite gradient, though, in the tidal creek. I think it goes from 3.9 to 5.4 elevation.
It's true of the river.
Correct. And
And so is the river a tidal creek?
Yes, it could be. It's a tidal river. Yes.
It's a tidal river.
Right.
But the fact that it is the fact that it has water flowing in and out does not mean that the salt marsh extends all the way through and across that river.
No, it is not. It is tidal creek, and
If it's a tidal creek, this is where you are losing me, because your argument seems, if I understand it correctly, to be that a tidal creek is part of the marsh.
correct.
And if the river,
There's a
name
different
correct
definition
here.
of river.
If the Bluefish River meets the criteria that you are assigning to a tidal creek in that water is flowing in and flowing out,
It would not, because it is a river. It is not a creek.
what is it that makes it a river and not a creek, notwithstanding that water is flowing in and flowing out?
It would be the size of it, I think. I'd have to look at the definition
Okay,
of...
now we're getting somewhere.
I mean,
And so
there's the
when I
Rivers
look at
Protection Act.
Now, when I look at the aerial photograph and at the plan, and I look at the point at which this pier would end, I can see a fairly large expanse of water,
Correct.
so that the fact that water is flowing in and flowing out doesn't necessarily determine the question, does it?
Whether it's open water or whether it's to the water's edge.
Whether it's the water's edge, right?
That actually hurts the plaintiff's argument because at low tide, there's zero water.
I understand that, but that's true on any tidal flat.
Isn't that also true of where a lot of these other piers all around? They're on tidal flat at low tide?
Not all of them, and I'm not,
Any of them?
I'm not certain.
I don't have the
Your Honor,
benefit that the judge had of a view, but I suspect that the area just to the north of this pier on Bluefish River is probably wet mud at low tide.
The site visit was mid to high tide, unfortunately, so
But I'm
I can't
just
answer your...
making an observation that if I'm looking at Exhibit 16H,
OH.
and I go to the far upper left-hand corner of that picture, that much of that area is wet mud at low tide.
Again, I
I understand.
can't answer that, Your Honor. I
Just trying
do
to understand
apologize.
how much your argument would prove.
So, one thing I
Do we have any
did...
further questions?
I don't.
I think we really should move on. Thank you.
Thank you.
Okay, for the plaintiff, please.
Good morning. I'm Paul Driscoll. I represent John McLaughlin. I have since 2010. I, of course, had an order that I wanted to follow here. But with the court's permission, I'd like to try to elaborate on the answers to some of the questions posed to Attorney Quessel. First of all, Judge Green, a couple times you have said open water. And I just want you to know that open water doesn't appear in any regulation. It's water's edge. Right. I also want to tell you that all three witnesses in trial testimony, including McLaughlin's two experts and the zoning board's expert, agreed and so testified under oath that this reaches water's edge. And when you find that testimony, you will find that Lenore White agreed it would be water's edge when it was high tide, water's edge when it was middle tide, water's edge when any water would be there.
And therefore, it's a flat.
I'm sorry?
And therefore, it's a flat?
No. Well, I just want to stay with this water's edge for a minute. Justice Blake, you asked about the dogleg. The dogleg in the construction of the pier. This dogleg is not prohibited. This dogleg is not the only dogleg in Duxbury. And this was not turned down because of a dogleg. This was turned down after being approved by the zoning board on all special permit conditions as they regularly appear in the bylaw, and in non-compliance with one provision that occurs in a bylaw provision that deals with residential piers. And if I might explain it to you, because it's always bothered me that their position doesn't make any sense. If I could ask you to follow this hypothetical, if McLaughlin only had 30 feet of vegetated salt marsh behind his house, and then there was 20 feet of water at high tide, and then on the other side there was a salt marsh that did not belong to him, they would be taking the position, according to their view of the bylaw, that he would have to cross the 30 feet and then completely cross where water was of 20 feet. And there are provisions in the bylaw under 40420, I think it's subpart 1 and subpart 6, that say that you can't build a pier that impedes navigation, and you can't, and not only that, but the last 2 bents, which are the last poles in the vegetated salt marsh, can only be placed 2 feet into the water from the end of the vegetated salt marsh. So their entire position that to comply with the 200 feet, an applicant would have to go all the way across the salt marsh and all the way across the tidal creek, if there is one there.
Can we, I'm
yeah.
sorry, I actually read this hypothetical in the testimony yesterday, but Judge Blake asked a question that would be great if you answered, which is, if is it then on the tidal flat? Is that your position?
Sure. Tidal flat is defined by the SJC in the Arno case, Your Honor. And their expert, Lenore White, had never heard of the Arno case. And it's not only Arno, but there's another one after it. In the Arno
The answer is, it is on the tidal flat, or it's not on the tidal flat?
The pier?
In what Judge Blake asked.
Oh, it's the pier, according to the plans, the pier is on a vegetated salt marsh. The ramp goes down to the float, and the float is on a tidal flat.
The float, so the answer is yes.
Absolutely.
Because it has then reached open water, in your view.
Water's edge, Your Honor.
Water's edge, my mistake. Because it has reached water's edge, it is on a tidal flat, is your view.
No, it's on a tidal flat because that's what happens to be there. It's a tidal flat, as defined by Arno. Arno said that a tidal flat, second line in this SJC case says we're going to define tidal flat. And the tidal flat is from mean high to mean low, or I think it's 100 rods, whichever is lesser, and a rod is 16 feet. But in Duxbury, all the experts that deal with these things consider within the Duxbury quadrant that mean high is an elevation of 9.5 feet, and mean low is 0.0. So on McLaughlin's plans from day one,
Right.
in the area
I got it.
Sure.
I got it. I have another question.
All right.
And I don't know if you have it in front of you, but Judge Blake asked a question about 16H and about where the float is located on 16H. In 16H, the float, and this is the problem with trying to do this, but
Right.
there's a finger, as Judge Green described
Right.
it, that kind of comes in toward the McLaughlin house, and the float's going to be on that finger. Now, there are 3 or 4 or 5 other fingers to the right of this finger where you're going to put the float, and they're much narrower in terms of that finger, or of the area that's not salt marsh, it looks like. If you were going to put, instead of where the float is, if the float were, say, halfway up one of those much narrower fingers, would you be taking the position that it was, what's the word? Water's edge?
No, Your Honor.
And what's the difference?
The difference is that the testimony is that those are what are called I'm searching for the second word. Those were dug man-made to drain the marsh so that there won't be an accumulation of mosquitoes during the season. Those are man-made. You see how parallel they are?
Yes.
You see how they're all the same?
You see them from the air whenever you fly over this
Those
area.
are what they call mosquito ditches, Your Honor. That has nothing to do with this project and would have nothing to do with
I'm
any
guessing that
other.
they have not been effective to deter the mosquito population.
They have not.
So that's interesting to me. So I read a fair amount of the testimony, and I didn't see anyone distinguishing, as you just did, between those ditches and the area where you're putting the float pursuant to the plan.
My memory is, Your Honor, that Mr. Brogdon did testify. I apologize if I'm wrong.
I will take a look at that. Thank you.
Yeah, my memory is that he did, but the fact of the matter is that issue was never a matter of contention between anybody in this project. Nobody ever.
Well, the contention is, what is a tidal creek?
Well, I understand, but see, here's the problem, and this is the basic problem. Tidal flat is defined by Arno. Brogna and Gray knew that. Lenore White did not. She also didn't know that Duxbury uses elevations of 10.5 and 0.0. She didn't know that.
You can read what the judge determined about the battle of the experts, if you will. But
Right.
what, if anything, should we take from the fact that your client's initial plan labeled what was to result as a title flat?
What should you take from the fact that this?
I mean, if you, a cynical view of the proceedings would suggest they knew they were going to lose, so they had to regroup and call it something else.
I think you misspoke. Did you mean Title Creek rather than Title Flat?
Yes, I'm
Okay.
sorry, did I switch them?
Yes, you did.
I apologize
All
for
right,
that, thank you.
Yeah, Your Honor, here's the key point. First of all, how Title Creek got on the plan was fully not only testified to by Bob Gray, but also analyzed by Judge Smith.
Right, are
Okay?
you saying
All
we
right.
should pay no,
No, what I'm saying, the further point, which is the main point, is if you look at the plan, where the words Title Creek go, that's not where the project is going to be built. And from day one, from all 5 iterations of the plan, where the float is going to go, the words Title Flat appear. So Title Flat is on the plan.
so what exhibit are you looking at? Are you
It
looking
would be,
at,
I think it's Exhibit 1, Your Honor, or Exhibit 2?
well, in the record, is it record volume 1, page 686 that your sister referred me to?
I'm not sure, Your Honor, I can't verify that.
So
It's trial
there's a
Exhibit 1.
sketch, and if we're talking, using the word finger, that labels Salt Marsh, Title Creek, Title Flat.
That's right.
Is that what you say?
I don't have it in front of me, Your Honor. It's the 8 pages of McLaughlin's plan. And it's sheet 2 on those pages, and they show,
Sheet 2?
I believe, and they show where the float would be. And showing where the float would be, it says Title Flat. And that plan, as happens in these kind of things, was changed several times, and every iteration says Title Flat.
Honestly, that's at 687. To me, the float is halfway in what's labeled the flat and halfway in what's labeled the creek, but I guess we can resolve that. What if we agree with you about Judge Smith's decision, but we determine that it should have been remanded to the board?
All right, that is a catastrophic result for many reasons.
And you know
And
it's rare. The
and
result here from the trial court was, that's a rare result, that a land court judge would order the board to issue the special permit.
Oh, I understand that, but there's...
So why in this case is it okay?
Well, first of all, it dovetails with something that Justice Englander brought up. If it goes back, if it's remanded, can they have evidentiary hearings? In the Wendy's old-fashioned hamburger case, says that when it goes back, they are bound by what the judge found. Here's what it says. It says, on remand, a board may not ignore or disagree with specific findings of a reviewing court after a judge has fulfilled his statutory duty to determine the facts. So that...
Where would that leave the proposed interveners, if anywhere?
The proposed interveners who tried to intervene and it was denied, and by the way, they didn't appeal it.
Right.
And they could have, because they sought to intervene as a matter of right. So they could have appealed it. They didn't appeal it, and they would not be able to change the order. The order of the, if the judge's order that the permit issue remains unaltered, if it's not reversed by this court, there would be no evidentiary hearing, and there would be no right to participate.
Would there be a hearing as to potential conditions, and if so, do the interveners have a role in that?
No, because here's what happens, Your Honor, as a practical matter, and I talked to Paul Brogner, the engineer, about this yesterday, and he's done 60 piers in Duxbury as his testimony. There's a form, a 3 or 4 page form on the issuance of a special permit. And the early part of it is they make reference to the applicant's plan, and they recite what is going to be done. And Attorney Questle was talking about conditions and materials and everything. That's all done according to the plan. And then you come to the final place and you say reason for the decision. And in this case, because of Judge Smith's order, the reason for the decision, the board would simply put in that it is being issued pursuant to an order from a land court judge.
I don't understand this answer. I think Judge Blake is asking about whether or not, if it went back, conditions could be imposed with respect to the special permit that we've indicated that, sorry, we would be the wrong thing, but hypothetically we,
Right.
affirming the land court's decision, would be ordering. And what's the answer to that question? Could
No,
conditions could not be imposed?
Only the conditions shown on the details of the plan. So they.
Why is that?
Because that's what was applied for, materials, distances, space, et cetera, et cetera.
But applicants for a special permit routinely file a proposal, and then in the back and forth that takes place at the public hearing with the board, the permit granting authority, there are any number of and variety of different types of conditions that may permissibly be imposed, quite apart from those that were included in the permit application itself.
We're getting to the point that we have to remember that the trial was on a single factual issue and that the decision of
Yes, but the board never reached the question of appropriate conditions because it denied the special permit request.
I would respectfully disagree, Your Honor. The board specifically said in about 9 or 10 paragraphs that this application met, and then they listed all the criteria for
Those
special
were
permit.
the underlying performance criteria for eligibility for a special permit. But that is a different question from what conditions may be appropriate should the permit be granted.
Well, I heard earlier in some colloquy about whether such conditions would deal with wildlife and things like that. And my answer to you respectfully is those are exactly the issues that were determined. So to my knowledge.
We're not here to talk about the subject matter of those conditions in detail. But your contention is that it would be impermissible for the board to impose conditions of any kind on a remand.
My understanding.
And I guess I'm having difficulty
Okay.
understanding the source for that assertion.
All right. To me, it's the difference between a remand. We've all seen remands for further proceedings consistent with this decision. We've often seen remands like that.
A remand to a municipal permit granting authority is very different from a remand from a reviewing court back to the trial court.
It depends upon what we mean by remand, Your Honor. I suppose you have to remand it for them just to follow Judge Smith's order. But when I use the word remand, I take it to mean in the colloquial sense, remand it for essentially new issues, new evidence, start from square one.
No, I mean, in the Section 17 appeal context, a remand really has a different character, and everything that happens has to be done pursuant to a duly noticed public hearing.
Can I, you may have thought about this, you may not have, but one of the things that the amici say is that because they were denied intervention, they were unable to raise what they claim, and I have no idea whether there's any merit to it at all, would be two other issues. One is the one that Judge Blake mentioned, I think, which is that there's another pier on the site, and the other is that they claim to have a recorded preservation restriction. If we were to affirm, well, I guess the question is, what do you say to that?
Well, first of all, with the other pier on site, what happens is McLaughlin's lot is on Washington Street right here. Next to him, there's a property owned by another lady, I forget her name. And next to her is the Bluefish River. In order for her to get her, the way the lots are configured, in order for her to get a dock on her property, which she had, her walkway, elevated 4 feet above the marsh, has to tick the corner of the McLaughlin lot. So if there is not another pier on McLaughlin's lot, there's a place where someone else's pier goes over the corner of his lot 4 feet high for a stretch of about 6 feet. So that's, I forgot the second one you mentioned, Jeff.
Say that there's a recorded preservation restriction as to which certain of the...
The preservation restriction says that piers specifically allowed. It's pretty interesting. The preservation restriction was entered into by a bunch of people who lived in that area many, many years ago. And it was, you can't do this, you can't do this, you can't do this, and we all agree. But you can have piers if you get the permits. So when the reservation restriction is called that, the implication is it's restriction, and it really isn't. If I can get back to the central problem that Judge Smith found with Lenore White, is there is no definition of Tidal Creek. So she said that it was acceptable for her to look at the definition of creek. And there is a definition of creek, but the definition of creek says same as stream. So now, two moves removed, we find ourselves at the deposition of stream, and stream means, this is from 310 CMR 1004. Stream means a body of running water, including brooks and creeks, which moves in a definite channel in the ground due to hydraulic gradient.
Right, but why do we have to accept that? Because by the time you get, as you say, 2 steps removed, you've taken the word title out of the definition.
No, our position is you don't accept it, Your Honor. That's
Okay.
why
All
Judge Smith did not credit her testimony. And as to the running water, she says the tides ebb and flow as the running water, and Bob Gray, who's been a certified wetland specialist for about 40 years, said that that references to fresh water. So Lenore White, and this was very, very significant for the judge, she did not visit the property, and he mentioned that in his decision 5 times. So she undertook to say that a tidal creek was there, and she never did a site visit.
I think we'll have to leave it there. We're over
Thank you,
time.
Your Honor.
Thank you. Thank you both. The case is submitted. That concludes our session. Thank you all.
Court all rise.